As everybody knows, it's a challenging year from the business community perspective because there is a supermajority in both houses, right? Supermajority meaning that the Democrats have a two-thirds essentially in each house, and that's especially significant for taxes because that's the vote threshold that they need in order to pass any taxes. And you would think, hey, we just had this election where the personal income tax increases were extended, the state doesn't need any more revenue, revenues are actually higher than what the governor anticipated in the budget, why would anybody expect more taxes? Well, there are social programs that a lot of members want to fund, such as the single health care issue. There's a lot of directed excise taxes on specific industries that have been introduced to, again, fund social programs like rehabilitation for drug abuse and free, tampons that aren't subject to the sales tax, diapers that aren't subject to the sales tax, and imposing a tax on distilled spirits in order to pay for those issues that people are socially in favor of, but don't want to actually, deal with the fiscal costs. So that's a lot of the tax proposals that we're seeing. Senator Lara, who is also the author of the single health payer, also has a pretty significant tax increase out there that's actually on the Senate floor right now, which would increase personal income taxes for those high income earners who are already the highest taxed in the nation right now under our personal income tax at 13.3%. They would do a capital gains tax for inherited property. If you have $1 million, you would be subject to a capital gains tax on inherited property. And then, of course, they're going after CEO compensation because it's a political favorite thing to talk about, but they don't appreciate the disincentive it would have on companies locating their CEOs here in California. And so that tax increase is out there. It's on the Senate floor. And why we think ultimately a lot of these will be stopped and they won't get it, the two-thirds in both houses definitely makes us concerned when we see these tax proposals getting to the Assembly floor or the Senate floor. So that's on the tax front, kind of what we're dealing with on the challenges with directed or targeted taxes or ones dealing with CEO compensation and things like that. The two-thirds in both houses is also difficult, even for our majority vote bills in the labor world and legal reform world, because it just makes it that much tougher for us to get the votes to potentially stop some of these problematic bills. So over in the Assembly now, we need about 20 members to agree with us on our position, and that's on the Dem side, and including then obviously all the Republicans as well need to be with us. And then on the Senate side, it's about 8 members that we need to get. And so it's a tough mathematical equation to get there to stop a lot of these bills on either side. And some of the labor issues that we're dealing with are really socially popular. Gender equality across the board is a huge issue here in California. It's a national issue, and it continues to be an issue that comes up year in, year out here in California. And as everybody knows, a couple of years ago, we worked with Senator Jackson to support SB 358, which strengthened California's equal pay law, trying to, set the standards of what companies needed to do with regards to substantially similar jobs and equal pay for those positions. But since then, we continue to see bill after bill kind of, I would say, add on the burdens onto employers. This year, one of the bills that we're dealing with, and thank you to everyone who has weighed in with their legislators on this bill, we appreciate it, is AB 1209, Assemblymember Gonzalez bill that requires companies with 250 or more employees to publicly post on their website the average salary between men and women in the same job title. And so, of course, you're going to see wage disparities, right? And it could go either way. You could have a woman making more or a man making more. You're going to see wage disparities. But what you don't get is the context behind why those wage disparities exist. Maybe the woman has only been in that job title or that job position for a year and the man's been there for 20 years. Maybe she doesn't have as much experience. Maybe she only works part-time. Maybe some of her personal choices on her compensation, such as contributing to 401ks or making deductions for dependent expenses, has reduced her salary down, and that's why there's a disparity. It has nothing to do with whether or not the employer is engaging in kind of like this wage discrimination. And so we're super concerned about that bill because it only gives you this little snippet of information, but subjects these companies to public shaming for people who are saying, oh my gosh, they're engaging in wage discrimination, this is terrible, when actually they're not violating the law at all. So we're super concerned with that. But it's a difficult issue because nobody wants to not be for gender equality. Nobody wants to say that women shouldn't be being paid the same as men in the same job title. So it's super challenging on those issues. On the legal reform front, arbitration is still an ongoing debate. That is going to be an ongoing debate from here on out. I know Karen has a bill on arbitration that she's dealing with in the healthcare world. I'm dealing with an arbitration bill right now circling around a financial institution that had some issues with accounts being opened without the consumer's consent, and those issues being sent to arbitration. And they're utilizing difficult facts and difficult issues. It's being sponsored by the trial attorneys who are constantly trying to erode away arbitration because they don't want cases to go to arbitration. It's much more financially beneficial for them to go to class action litigation. And so they continue to try and erode away, and this happens to present really good facts for them to justify why arbitration should be eliminated. So it puts us in a difficult position because the United States Supreme Court, the Federal Arbitration Act, it doesn't say, hey, just because there's some unfavorable facts out there or something happens that the public doesn't like, you get to erode arbitration. They actually say, no, you can't treat arbitration any differently, and if there's an agreement to arbitrate, you go to arbitration. So we're constantly trying to preserve the right for companies to go to arbitration and avoid this class action litigation, but it's challenging, especially when you have some of these public high reported issues out there, and members are sympathetic to the fact that consumers, were taken advantage of from that perspective.